If you modify your defensive firearms trigger, the prosecutor may use it against you to show that you are reckless, arrogant, and maybe even negligent in their case to put you behind bars. True. But will it stick in court? And is even a low chance of it sticking still worth the risk? My name's Tom Grieve. I'm a former state prosecutor, criminal defense attorney, and together myself and my many skilled attorneys at my law firm have represented many, many good people who've been forced to use firearms in self-defense in the street, car, and home. This video will give you the academic knowledge and the real-world data points, as well as anecdotes from the streets to the courtroom. I hope that you find it informative. Let's get into it. But very briefly, before we get going, please consider showing your support for the Second Amendment by clicking like on the video, subscribing to the channel, and sharing with your friends. We are a small channel, and as you already know, I'm a full-time attorney, and the larger the channel gets, the more time I will be able to justify spending in order to create content, researching out more video topics. So again, thank you, and now on with the show. This is something that's very difficult to underscore. Your self-defense trial will likely not look anything like how you probably think it will. The justice system from the inside is a very different place than how it looks in the movies and in the media. Without getting off track, I want to bring your attention to a massive, singular mistake that people make when they play things out in their mind. This will not be a jury of your peers. Period. It will be from a legal sense that they come from the community and there are certain protections in place for minorities and so forth. So sure, in that sense, it will be a jury of your peers. So it may resemble them, at least in outward appearance. However, the prosecutor will likely move heaven and earth to ensure that not one firearm person makes it onto that jury. The prosecutor, who as a reminder gets to go first in jury selection, or perhaps better thought of as practiced in real courtrooms today as jury deselection, will likely start by trying to identify anyone who owns guns, shoots, hunts, belongs to any gun clubs or Second Amendment advocacy organizations. Odds are that most of you watching this video would be the first targeted down by a prosecutor to get you kicked off the jury. They will do this, very briefly, by first trying to show your biases in favor of people who claim to act in self-defense, who own guns, among many other angles that both myself and other attorneys have seen in court. Now that will work on many of you who probably don't want to be on the jury anyways, and as a result, may allow yourself to follow the prosecutor's lead so you can get off the jury and get back to your life. Fair. However, the few stubborn folks who are wise enough to the prosecutor's game and smart enough to avoid the landmines will likely be struck using one of the peremptory challenges that both the prosecutor and defense side gets in each trial in order to dismiss jurors for virtually any reason at all. Or let me explain this jury deselection another way to you. You know that cousin, that aunt or uncle who you argue politics with at holidays all the time? That person who always says that no one should own guns, that you should just surrender to the home invader because, you know what, they almost certainly won't hurt you anyways, they probably really need the money, and they genuinely believe that hanging a sign outside that says gun-free zone is an effective deterrent to evil.
Everybody takes a beating sometimes, right?
That person is who the prosecutor wants on your jury. That is the person that probably also wants to be on your jury. And a smart prosecutor who understands how to rehabilitate jurors who they run into with problems before the defense team can touch them can often do a lot to saddle even a skilled defense attorney with some prospective jurors that they now have to burn their peremptory challenges on rather than being thrown out for cause. So why the game? Because the prosecutor knows that if you have what you and I may consider to be good facts, that they may need to convince people that those facts are in fact bad, or the game itself was bad. In other words, they may try to change the whole paradigm. Here are a few examples to help illustrate what I'm talking about. Imagine you have a defensive gun use jury trial. You, the defendant, was surrounded one night when getting into your car in a dark parking lot and began getting pummeled in the dark by 5 unarmed attackers. And just as you're losing consciousness through your blood-soaked vision, you pull out your firearm, shooting once, and now you're suddenly facing homicide charges. Why? Because the prosecutor says that you can never use a firearm versus an unarmed attacker. Don't think this is real? Remember, one of the prosecutors in the Rittenhouse case says that everyone has to take a beating every now and then, and basically using a firearm versus an unarmed attacker, that's basically disregard for human life. Therefore, prison. This is very real. Or how about the career criminal recently released from prison who was charging you with a knife and they were only 10 feet away when you opened fire, stopping them and saving your life? But hey, why didn't you wait for 5 feet or 3 feet? Surely that is murder. After all, someone with a knife cannot reach you from 10 feet away, right? See my video on that, by the way, linked in the description below. I could go on, but I think by now you get it. So what does all this have to do with trigger modifications and modifying your firearm? Nothing. Everything. Let me explain. What the prosecutor will fundamentally argue at your trial is that you are a bloodthirsty bad guy looking for a fight with a gun. As evidence of this, they'll point to the fact that you had a concealed carry license. They'll point to the fact that not only you had a concealed carry license, you were actually concealed carrying a firearm on you. Not only that, it wasn't loaded with just any ammunition. No. These had special cop killer hollow point bullets in them. Right. Again, real things I've seen prosecutors argue in court, mind you. And of course, to land what in their mind will be the coup de grace, the finishing blow, they will launch into your firearm modifications. Remember, the prosecutor will say that the manufacturer set your firearm's trigger at 5.5 pounds pull weight from the factory with X distance of pre-travel, Y distance of post-travel, reset distance, and so on. That's good enough for everybody. After all, that's what the manufacturer did. Except for bloodthirsty you, the defendant who thinks, strike that, the defendant who knows that they are smarter than the manufacturer, the defendant who needs a firearm that is more lethal than even what the manufacturer is capable of turning out. That 5-shot J-frame revolver may have been good enough for some retired cop that they know, and rest assured, they'll tell the jury about, but you needed 15 rounds in your magazine when you left your home that day. You actually carried with a round in the chamber. They will try to build a case based on you being arrogant, impulsive, and reckless, and weave through the facts and likely the many disputed he said, she said that may come with your case and come out in the testimony. But it'll be the rock that they keep coming back to in order to show that you always feel like that you know better and you need something that's more lethal. Or maybe your case will be different. Maybe they could also try to use it instead, or maybe in addition to show that you actually negligently discharged your firearm, which could be a way around the prosecution from having to deal with your self-defense claims head-on, subject to your state's laws. So be sure to check your local listings. But that's right. It could be a nifty sidestep since you cannot intentionally commit negligence, and self-defense acts means that you have to have acted intentionally. Does this not sound real? Watch real trials again. Watch State v. Rittenhouse again. I have been in court personally when judges and prosecutors have referred to all hollow point ammunition as cop killer bullets. And likewise, when all full metal jacket ammunition has been characterized as military grade ammunition that no civilian should own or possess. Right. These are real stories from real courts. By the way, if you want to know more of these kind of stories, let me know in the comment section below. Now, let's balance this out. Look, at the end of your case, what the judge will do is to instruct the jury on how they are to apply the law to the facts, known as jury instructions. Nowhere in those jury instructions will you hear the phrase, and if the defendant modified his trigger, then you shall convict him. That is all to say that the prosecutor's game should not be able to subtract from what was fundamentally either good shoot or bad shoot. But that does not mean that your defense will be improved by forcing your attorney to deal with a river of avoidable prosecutor arguments. Don't be one of those future clients who thinks that any good defense attorney can make everything that is bad or inconvenient disappear with a few pieces of paper, or maybe a flick of the wrists, although that would be nice. First off, it's the gun that you used, and it's going to be part of evidence, period. That means that the modifications, decals, whatever window dressing you put on it has a high chance of being heard by the jury. Secondly, that it is simply not the way that it works in real life. In real life, the judge is the one who makes the calls, not your defense attorney. Judges are people. Many are great and are able to call balls from strikes, and by applying the law to the facts, able to reach sensible, reasonable decisions that is consistent with law and precedent. However, from time to time, a few have been known to take either personal or political grudges to the bench with them. You may have heard about this before. Bottom line is that's where those decisions are going to ultimately get made in your case as far as what the jury's allowed to hear. Thirdly, unless you make blingy upgrades, there's actually, by the way, a decent chance that the police and prosecutor may not even notice a subtle trigger job. But keep in mind, once you start swapping out visible parts, the odds of that being noticed go up, and the odds of that not being pressed to come into court go down. So just keep that in mind when you're making your decisions. Also keep in mind that some of those bad arguments, by the way, that we were just covering before, that are completely nonsensical to firearm people, may actually work and move the needle among some of your jury. Remember our discussion about your favorite cousin who now sits in that jury? And even if it doesn't sway them outright, it is impossible to predict where else they might give back points to the prosecution if they felt like they made a call in your favor on this one. Trigger modification. Is it worth it to pay that price, the possible liability in the courtroom in order to modify your defensive carry firearm? I think so, yes, with a few important lines that you need to color within. Most of the triggers that come from pistols from the factory leave something to be desired. And by something, I mean a lot. Striker fire pistols like Glock, Smith & Wesson, Ruger, and others tend to come with heavy, long, creepy triggers set at 5.5 or 6 pounds, which in and of themselves isn't bad. But when we start taking into account pre-travel, over-travel, the wall breaks, resets, and so forth, it's not the best. Double action, single action pistols like the P-Series Sig Sauer, hammer-fired HKs, CZ, and Beretta, to name just a few options, may feature an 8 to 10 pound first trigger pull on the double action, which may come down to a 5 or 7 pound trigger pull in single action. And again, they can be heavy, long, with entirely unnecessary over-travel, pre-travel resets. And as a result, the sensation of pulling that trigger may be like rubbing sand into your eyes or nails on a chalkboard. While some pistol brands are known for shipping with some pretty decent and even downright good triggers, hello Walther, most pistols sold over the counter are like purchasing an untuned instrument. There's a lot of potential that can still be unlocked. But how does that happen? Most pistols will improve and sometimes substantially improve with shooting and dry firing over the course of hundreds and even thousands of rounds. Now, given today's ammo prices, that may sound insane to an accountant. Given today's comparatively affordable aftermarket drop-in triggers, the choice suddenly starts to look a lot easier. And it makes sense why someone would want to upgrade a trigger. And for those of you who are not firearm people, let me briefly explain this. Because at the end of the day, a more accurate trigger should lead to more accurate and faster shooting, which means we have a faster threat stop. The faster the threat has been stopped, the less danger the victims and innocents caused by both the bad guy's actions as well as the good guy's potential missed shots. Keep in mind that in a gunfight, a study of NYPD officers found that the police hit the bad guy with less than 20% of their bullets. So stacking the deck in the good guy's favor to make rapid hits makes sense. It makes life-saving sense. This, of course, also skips the fact that shooting a smoother pistol is inherently a better and, frankly, more enjoyable experience, like shifting the smooth gears on a high-quality manual transmission car or enjoying a refined adult beverage versus something cheap and bottom shelf. And look, I want to stress the fact that I actually encourage people to replace the crummy factory sights that come with most pistols. Get yourself a great pair of tritium or other night sights that work for you and your eyes. Weapon-mounted lights may need to be the subject of another video, so if you're interested, let me know in the comment below. So what can you change, how, and why? I do have 7 rules for modifying your defensive firearm, but it's not coming into this video. Watch for that video to come out next week, and hopefully we'll remember to link it in the description box of this one below after it does. So I hope that this look into trigger modifications was helpful. Please let me know what you thought about this video in the comment section, as well as any other thoughts that you might have about what you do to modify your triggers, the do's and don'ts of your personal practices, because I want to know. And keep in mind that I also do have an attorney answers series of videos. So if you've got questions, post them up and maybe they'll be a subject of a future video. Guys, if you've not already done so, please consider clicking like and to subscribe to the channel. Thank you for sticking around this long, and I'll see you in the next one.